With the publishing of the rules, Court-Annexed Mediation becomes a reality in South Africa's civil justice system. The rules offer an opportunity to attorneys to represent their clients during the voluntary mediation process. LEAD offers a 5-day workshop to train attorneys as mediators. This video gives a short summary of these rules. Let's start with an understanding of what is mediation really. Mediation is a flexible process. The mediator facilitates the negotiation between disputing parties from a problem-solving perspective. The mediator aims to move the parties to a solution that satisfies the needs of all parties. The benefits of mediation are: it is entered into voluntarily, it takes place off the record and without prejudice, and what is said in mediation remains confidential. Through the mediation rules, the Department of Justice wishes to enhance each citizen's constitutional right to access justice. Adequate access to justice is often not available to the most vulnerable of our society. Mediation aims to provide a dispute resolution approach that preserves relations between contesting parties. The resolution is often speedy and cost-effective. Mediation also aims to provide solutions which are beyond the scope and powers of judicial officers. It helps potential litigants decide whether or not a trial would be in their best interests. When can disputes be referred to mediation? Parties refer a dispute to mediation at any time, and this can be before the start of litigation, after litigation has commenced but before trial, or even after the trial has commenced but before a judgment has been made. A court may also request parties to consider mediation during the course of litigation prior to a judgment being handed down. Can mediation be done outside the court rules? Yes, your clients still have the choice to have their disputes mediated by a private mediator. Any resulting agreement can be made an order of court. Which cases are most suitable for court-ordered mediation? Any dispute can be mediated and resolved through an effective mediation process. Some disputes are more suitable, for example, where the parties are committed to the mediation process or want solutions beyond the limitations of court. Where the parties prefer the process to be outside of the glare of the public, mediation is also suitable. The business, financial, relationship needs, what happens to the time periods for court? The time limits prescribed by the rules for the delivery of pleadings and notices, the filing of affidavits, or the taking of any step by any litigant are suspended from the time of conclusion of an agreement to mediate to the conclusion of the mediation proceedings. Does the use of mediation interrupt prescription? No, the process of mediation does not suspend, stay, or interrupt prescription of any of the parties' claims. The onus rests on each party to take steps to interrupt prescription. Can your client trust the mediator? It is critical that the mediator remains impartial during and after the mediation process. In fact, the court-appointed mediators will be bound to act according to a code of conduct. Where a party no longer trusts the mediator, I would recommend that they find a different route or select another mediator with the assistance of the court. Who pays for the mediator? Rule 84, subsection 2. The mediator's fees are split equally between the opposing parties. A party may offer to pay the full fees. However, in my experience, it is better for all parties to pay towards the costs to ensure commitment and buy-in to the process. How much does mediation cost? The Minister has not yet published a tariff of fees for mediators. The fees will probably be in line with the Legal Aid Board tariffs. Hopefully, the Minister will provide in some way for the destitute. How long will mediation take? Rule 77, subsection 4, 5 and 7. The rules allow for the parties, in consultation with the court clerk, to agree on the number and timings of the mediation sessions. What happens when the dispute is settled? Rule 82. The mediator drafts the settlement agreement, which is signed by the parties. If the dispute is already a subject of litigation, a judicial officer on request of the parties may note the settlement or make such settlement an order of court. If the dispute is not a subject of litigation, the clerk or registrar will file the agreement reached. What happens if the dispute is not settled? Rule 82, subsection 5. If the dispute is part of litigation, the clerk must file a report from the mediator to enable the litigation process to continue. If not, the registrar must simply file the mediator's report indicating that the dispute was unresolved. Even an unsuccessful mediation process can help the parties narrow the disputed issues. Can information disclosed during the mediation be used as evidence in the court? Rule 80. Only the discussions and disclosures recorded in a settlement agreement signed by the parties may be used. All other information received during the mediation are confidential and not admissible as evidence. The mediation process. Usually mediation takes the form of a combination of joint and separate meetings between the parties and the mediator. The discretion on process rests with the mediator. The opening of the mediation normally takes place in a joint meeting. The parties are able to explore their needs, risks, and options much easier in a separate meeting with the mediator. A skilled mediator can use the process creatively to ensure efficiency and a greater possibility of the dispute being resolved.